let me just start by sharing the presentation that I have today. Historically, I think it's no secret that Singapore has always been, was actually founded by the British as a trading hub. So it is no surprise that we continue to function in that role today. But of course, with technological changes, with changes in economic structures, global trade, the nature and of this hub that we are trying to be of course has to change with the times. Yeah, so as I was saying that it's no secret that Singapore has always been a hub of sorts, and the challenge, of course, is for for Singapore to maintain relevance in this hub, as in the not just in the region but also in the world. And I think this is one of the founding imperatives that led to the creation of what we call the IP Hub Masterplan that has been guiding IPOS and what it has been doing since 2013. And there are actually three target outcomes that we set forth back in 2013. One is that we want to become a hub for IP transactions and management. Two, to become a hub for quality IP filings. And three, a hub for IP dispute resolution. Of course, just by saying that we want to be a hub is insufficient. Of course, we had plans and strategies in place that was set down in order to achieve these outcomes. And I think in most areas, we have succeeded. In some areas, we have not, have to be candid about this. And I think a lot of these things require us to learn and adapt as we go along. And I think one of the key things we realized early on in the role of IPOS and plans for its longer term plans for the IP office was that we were required to provide or train skilled manpower in order to drive this IP hub that we are envisioning. So this is one of the things that we are still doing today, and it is still an ongoing effort. I can see among the participants list members of the IP ecosystem. I can see patent attorneys. I can see maybe a few trademark attorneys, trademark agency and there. So these are some things we're trying to do to just improve the environment. I will not go into too much details here, but I think 2016, there was an effort to update the IP Hub Master Plan. And I think one of the key changes that we added on was the realization that there's actually a lot of R&D in Singapore that is actually government funded or government related in its origins. And there was I wouldn't say a need, but there was a recommendation, a strong recommendation that there is a standardized IP protocol for government research to guide how this research is best commercialized. And I think in the drawing up of this standardized IP protocol, we were quite conscious of the fact that it should not be overly prescriptive because there is a huge range of government R&D that goes on for different purposes, and as a result, we want to achieve different outcomes. So the challenge for IPOS and the other agencies they work with was to design a document that was sufficiently broad and yet to provide enough guidance for government agencies involved in R&D. We also realized that there was a need to focus more sharply on IP commercialization because by and large, most of Singapore businesses and research institutions did not have problems creating IP, but there was perhaps a lack of understanding or sharpness in understanding in how to take this IP to the market. So we invested some effort there. And of course, as a result of that, we also needed to grow a different type of manpower. So in the last 4 years since revision of the IP Hub Master Plan came about, last 3 to 4 years, we were focusing on training a different kind of manpower. So we were not just looking at creating or having more quality patent agents or trademark agents, but also quality IP consultants, or at least people involved, C-suite people involved in the creation of business strategy to be more IP aware in the way they drew up these business strategies. So these are the sort of things that we were focusing on in the last 2 to 3 years. We tried to pilot the IP financing scheme. We continue to emphasize quality in our patent examination and basically our grant process. And as a part of that, IPOS decided to become its own search and examination authority, not just for national files, but also for the patent applications that come under the PCT or the Patent Cooperation Treaty administered by WIPO. And we continue to focus on alternate dispute resolution. We think that in this part of the world, especially in Asia, that there is greater space for non-litigation type of IP dispute resolution. And so we've invested quite significant efforts in arbitration and mediation. We work very closely with WIPO on this as well. In fact, Singapore hosts the only other WIPO Arbitration and Mediation Center outside of Geneva. So this is what we've been up to since 2017. And I think as part of this process as well, we realized that while it is clear that IPOS wants to have a Singapore where innovative enterprises use intellectual property and intangible assets to grow, we needed different tools and different outfits to do that. So this was one of the key reasons why the IPOS International, a wholly owned company of IPOS, was created. And it actually houses the patent search and examination expertise, and also houses the enterprise engagement of IPOS. What this means is that while IPOS and my department under my other department, under the Partnership and Program Department, while we engage with industry groupings, business associations, trade associations, and of course, international stakeholders like EU IPO, other IP officers, global IP organizations, global IP associations, IPOS International was founded so that they could engage with companies on a one-to-one basis, where they could go to a company, sit down, understand their needs, and come up with more bespoke solutions and recommendations based on that. And IPOS International was intentionally designed not to have the capability to execute. So while we had people there who were able to make suggestions on IP strategies for each company, they had to rely on the IP community in Singapore, be it the patent agents, other business strategies, trademark agents, to execute the strategy that or strategic recommendations that I made to these companies. So this is where we stand today, and of course, going fine up to a point until sometime in say maybe January or February 2019, whereas everyone knows COVID-19 has hit. And I think in many ways, you could say that IPOS probably was not as affected by COVID-19 as other jurisdictions. Of course, we still had to take certain immediate responses. I think one of the key things that we did was to declare excluded days. Basically, what it means is that any deadline that fell between 7th of April to 4th of June 2020, incidentally, that the period where Singapore was actually locked down, they will not be taken into account in the calculation of these deadlines. So it is in effect an extension of sort. We also amended our subsidiary legislation to allow more leeway for the IP office to grant timeline extensions to certain deadlines as well, and also to give the registrar, which is the head of the IPS, at the same time greater flexibility in extending other types of deadlines. So I'm not sure if members of the audience are aware. Well, IPOS is the authority for IP in Singapore. Our powers and capabilities are quite well prescribed under the different acts. And I think for us to be able to extend deadlines is not something that we can do unilaterally without some form of amendment to the acts. So we rushed a series of legislative amendments in May and June this year in order to give us such flexibilities. But I think for the patent agents out there, please forgive us that we are still not able to grant extensions on an absolute basis. We still have restrictions placed upon us. I think the most important thing that IPOS had been doing to prepare for COVID-19 was the push towards digitalization. Since as early as 2014, various aspects of our IP filing processes had gone digital. In fact, we were fully digital by 2016. So applications of patents, trademarks, and even registered designs all handled under our electronic IP portal. In that sense, it made it a lot easier for us to pivot to digital services during COVID-19. Of course, there were some changes we had to make as well. I think we still run IP clinics, and we do have appointments with members of the public as well as companies who require assistance in their IP applications. We still help these people, but they were all conducted by virtual means since March 20, or rather April 2020. We even have experimented with the conduct of hearings virtually, and we are still trying to sort out the details, but in general, the plan is to have as many hearings as possible done online. It is allowed under the law. So this is what we did to cope with COVID-19, but we didn't stop there. I think we realized that there was a lot more that we could do in terms of digitalization. We had already launched IPOS Go in August 2019, which is filing app for trademarks. Basically, anyone with a mobile phone can actually file a trademark. One of the key advantages of that is that most cameras have phones, so it is easier for an applicant to upload pictures, be it their company logos or even pictures of the products that they wish to trademark. And we've built into this tool was an AI capability to check, to do a first level novelty check for these trademark logos, and that certainly was able to give applicants a better understanding of what they could or could not do vis-a-vis their applications right from the start. In August this year, we actually expanded the capabilities of IPOS Go to allow for the renewals of existing trademarks, patents, and registered designs. We will continue to look for other ways to expand the functionality of IPOS Go. But I think for those from the IP community, IP professional community in Singapore here, let me assure you that IPOS Go is designed for what we will call the 80 or 85% of applications that are fairly straightforward. There are still many applications that require the assistance of an IP professional, and our current systems do accommodate and will still accommodate those. Right? And we also have a accelerated IP filing scheme, which we call SG IP Fast Track. Basically, it allows for people with a existing patent grant in Singapore to be able to enjoy expedited trademark and design applications. The rationale for this is that we realized that many companies did not just have one form of IP, but they had actually a series of intellectual property, be it patents, trademarks, and designs, they even copyrights as well. So the idea we wanted to encourage is that companies should be able to appreciate their intangible assets better and therefore manage them as a whole. And we wanted to have schemes and platforms that enable them to do this. We realized that quite early on during COVID-19 was that different industries were affected differently. So we decided that there was a need to go down to each individual industry, talk to them, find out from them what problems they face and what we could do to help address these problems. And I think we had strong political level support from various ministers, not just the Minister of Law, but also for example, Minister Indrani, who's the minister in the Prime Minister's office. We had strong support from the Minister of Trade Industry as well, and many other agencies to sort of launch new programs and initiatives to help different sectors cope with COVID-19. And one of these was a whole of government initiative, or rather what we call an Interagency Initiative that works with different stakeholders. So, for example, we work with the Infocom Media and Development Authority to try and understand the difficulties faced by the digital media industry, for example, the broadcast industry, or even the IT industry in COVID-19. We were working with artists, performers, through the Ministry of Culture, Community and Youth, to sort of understand their issues and problems as well. Of course, the Singapore Tourism Board for Tourism Industry, the Sports Singapore, which is the agency looking at the growth of the sports sector in Singapore, as we're working quite closely with them. So these are just examples of current supporting agencies. The list is expanding. But basically, we do two things through this initiative. One, we go down to understand the problems that they face, and we work with them to come up with the solutions. Two, we'll see where possible if there's a way to tie some of the existing grant programs to assist these companies in their intangible asset management needs. We also decided that one of the key problems is the lack of information, or rather the lack of ease of finding information about the different programs that were already available for companies to tap on to help cope with COVID-19. So we decided to create a one-stop portal that lists all these programs available for companies to tap on. Examples of these are on screen. I shall not go into the individual grants. I can take questions on them later as well. And of course, IPOS itself, we decided to go all out in providing more information to the affected sectors. In August, we had our first ever grid webinar for the arts and entertainment sectors, where some companies that have successfully pivoted to digital platforms shared their experience in doing so with others. We continue to run IP business and legal clinics. In fact, we are increasing the capacity of these clinics now because there seems to be an uptick in demand as people need more assistance and advice on how to cope with some of the problems. We've launched a number of info packs specifically targeted at certain industries, one of which was the IP Arts info pack, which we launched in, I think, July, August this year. We are working on an info pack for the IT infocom sector that should be out by end of this year or early next year. We've sharpened our FAQs to address some of the more common questions on the pivoting of businesses to digital platforms. And we also launched a series of free business guidelines under IPOS International. So this is what we've been up to. The other thing is that IPOS International, the subsidiary company that I mentioned earlier, also decided go into what they call a technology scan reports. Essentially what these do is that they examine, they give quick overviews to trends in different industries or even different sub technologies within the industry itself. Examples of which include cloud security, human and machine collaboration, autonomous vehicles. The idea being that to use the wealth of information available to us as IP office to take a look at the pattern applications and to see whether there can be any trends, be it technology white spots or hot spots. And with this information, hopefully businesses are able to decide on where best they can put their R&D funds in. We also continue to generate thought leadership articles, both at IPOS and IPOS International level, to address some of the more topical issues facing businesses today. Of course, one of the more popular articles was a recent one on the role of IP and in the cure and or vaccine for COVID-19. So these are activities that we intend to continue. And of course, nothing can be done without the necessary resources. And so we've continued to work with our other government agencies, in particular Enterprise Singapore, to sharpen and at the same time to make more flexible the use of these grants to help businesses expand their business overseas. So I mentioned earlier, we run IP clinics. So the IP clinics, one-off clinics, each business entity is only allowed to utilize a business or legal clinic once, and this is for a 45-minute session. The intent of these sessions are to give the businesses top-level advice in that one session on their IP problems, be it, for example, business expansion or potential litigation. For example, businesses that have been served with a cease and desist letter, and they can get advice from us in a quick 45-minute session on what to do with it, or that they are aware that a competitor is infringing the IP and they wish to get advice on what they can do. We limit these sessions to one session per business entity only because the intention is for them to engage the business consultant that served them under these clinics, or to engage their own lawyers to continue work further. This way, we feel that we can both help the IP professional industry grow, while at the same time give much better access to businesses, especially the SMEs. One of the key findings that we had in 2016 and 2017 was that many Singapore companies, in particular the small and medium-sized enterprises, were underappreciating their intangible assets. Many of these companies had a wealth of intangible assets, be it customer data, be it their patent holdings, their trademark holdings. I think one of the key problems is that because they did not value their intangible assets correctly, they did not, they were not able to manage them in an optimal way after that. So what IPOS International did was it launched a IP advisory program that basically starts off by an intangible asset audit. Our consultants will go down to the companies, look through their businesses and identify possible intangible asset areas. These are not necessarily IP, registrable IP, but they could also be what we call sub-registrable IP, examples of which are business processes, customer data, or even database data that they've collected in the course of the businesses, and to suggest ways they can better monetize them. So this is, but of course, all these starts with an IP audit. Intangible asset audit. And we've also made more accessible our alternate dispute resolution mechanisms, one of which is the provision of a $10,000 or up to $10,000 grant for companies that use mediation services. So details can be found on the website. And I must say that there's a lot of interest in this program, and even one or two success cases so far. It doesn't stop here. I think by and large, many Singapore companies are well aware of the geographical and market constraints of Singapore size. And I think IPOS is also cognizant of that. And we've been assisting companies in taking their IP abroad as far as possible. We are members of the PCT, Madrid, and Hague schemes administered by WIPO. At the same time, we've also worked quite hard to become a member of the Global Patent Prosecution Highway, which currently includes 25 countries among its participants. We also have established a form of a patent prosecution highway with ASEAN, and we continually try and update and make this aspect scheme more relevant to businesses. So we've introduced even industry-specific expedited filing services. For example, a company in or business operating in the fourth industrial revolution space is able to enjoy expedited patent prosecution within ASEAN under Aspect AIM process. We've also recently updated Aspect AIM to allow the use of PCT reports from one of the two ASEAN IS, currently one of two current ASEAN ISAs, International Search Authorities, to expedite applications throughout the rest of ASEAN itself. We also are working on, we have worked with and actually have arranged for mutual patent recognition agreements with Cambodia, Laos, and Brunei, some of which are still being implemented, but by and large, we will be already implemented or will be implemented soon. We are also working to be recognized by more IP officers as a patent search examination authority under the PCT. Currently, we have 11 countries that recognize us, and we hope to grow that list so that we can make it easier for businesses to take their patents overseas. I have to say here that all of this, the IPOS is done, because I was a bit concerned by the title that our colleagues from the EYIPO had given us. I think the key point that I want to make here is that all of these hub plans that we have and execution of which will not be possible without what we call a whole of government approach in Singapore. IPOS is a very small agency compared to the rest of the Singapore government. We are only about 180 strong, in fact, about 150 strong. If we include our subsidiary company, we're about 300 strong. So it's actually not a lot of people doing the work that has to be done. And much of the funding, the grants, and even the access has to be conducted in close cooperation with our other counterparts in the Singapore government itself. So this does not just extend to IP awareness or even IP commercialization, but also in the traditional forms like IP enforcement. So we work very closely with many agencies, the police, customs, to enforce IP rights in Singapore, and of course the courts as well. The role of IPOS as an economic driver will continue in the years to come. I think that has not changed, but the details of which, the methods of which that we are going to do so will likely have to change. I think there are many out there, while the verdict is still unclear. Many economies are predicting a K-shaped recovery, where you see certain industries doing far better than others. And I think the job of governments all around the world, as well as IP officers, is to find ways to help companies that are doing well do better. At the same time, to help companies that are not doing so well pivot to other forms of economic activity. It will be difficult, and it's not just an IP issue, certainly, but this is something that we are thinking quite hard about. And in fact, this is one of the key driving forces behind the recently launched GREED program that I mentioned a few slides back. GREED is industry specific for this reason. And then the other issue that we are confronting today is that there appears to be a trend towards what we call technology bifurcation. In other words, you're going to have, without naming the names, we're going to have two, maybe three, maybe two very large technology centers where you've got IP standards coming out, whether it is new forms of telephone communication. So 5G today is a global standard, but maybe the next version of 5G, 6G could have two different standards, like what we saw between GSM and the rest of the other standards about a decade or so earlier. Is this good for business? We do not know, but this has implications. For many of you who are familiar with IP, patents actually in particular sets are actually a key component of standards. So how does this impact the way we operate? I think one thing for IPOS is clear, and that is any patent that comes through IPOS as a first filing, we have to examine to the best of our ability, because if these patents go into the pool of standard essential patents, they will need to be as robust as possible. And we need to invest great effort in ensuring that the relevant novelty checks are made. We need to have an understanding of what happens in both these technology centers, including an understanding of the patent literature that emerges in their respective languages. IPOS is, fortunately for cultural reasons, if it's not obvious to members of the audience, I'm ethnically Chinese. I do read Chinese, but although my capabilities in the Chinese language are certainly not as strong as others, one of the only IP offices outside of China that's able to process patent applications in Chinese language itself. And I think this will put us in good state as we try to adjust to the emerging technological trends. But by and large, while these trends probably not going to be positive for the end user consumer, we as IP officers certainly have a role to play to ensuring that we do not end up aggravating the problem. Of course, with the rise of different technology centers or different standards in technologies, you will probably see a rise in IP disputes. And I think we need to set in place the correct mechanisms to deal with these disputes. Litigation by far is still the most lengthy and costly method of dispute resolution. And I think we find that maybe there is even greater scope and need for alternate dispute resolution mechanisms, which we are trying to invest in today. So this brings me to the end of my presentation. I have to end off by saying that IPOS has come far through the help of not just the whole of government approach that we have in Singapore, but also through the assistance of our partners, the EU IPO, for example. We are quite clear that there are 5 strategic trusts that will continue to be our foundation moving ahead. One of which is ASEAN. ASEAN is key to Singapore, both as a market as well as a source of technology, and we hope to continue to function as a gateway into ASEAN, of course, with the assistance of our partners in the various other ASEAN IP offices as well. We wish to make companies more aware and able to use their intangible assets better for business growth. We want to go into IP valuation. We want to, if possible, set up or work with global partners to set up valuation standards. It is our strong belief that only with these standards in place can we actually set up a viable IP marketplace. I mentioned earlier, we will continue to put in effort to become an IP dispute resolution hub. And I think for all these other strategic trusts to come to fruition, we need the right people for that. So we will look into long-term training. We will look into conversions, professional conversions, so that technology transfer officer in, say, a institute of higher learning or research institute is able to have more options, more employability options later on in his career. So these are what we are likely to guide us. They are likely to form IPOS's core activities in the near and in fact the medium term future. With that, I come to the end of my presentation and I welcome any comments or questions. Thank you.